I welcome you to the second part of this video, Introduction to Criminal Law. I posted the first part a few days ago, so I do hope that people will check it up. As I said, Introduction to Criminal Law. My discussion in this video will be based mainly on the position of the Nigerian law, and references will be made to criminal laws of some other countries where necessary. This is the outline of the presentation: criminal statutes, some basic principles governing criminal law, elements of an offense, defenses to criminal liability. Learning objectives. Number one, at the end of this presentation, I do hope that listener will be able to understand, know different criminal statutes, know what needs to be proved in a criminal case, and finally understand types of defenses to crimes. Criminal statutes. We have criminal code in Nigeria and we have penal code. So criminal code is the criminal law, the major criminal law that is applicable in all the 17 southern states in Nigeria. Each state in the south has its own criminal code law. We have criminal code law of Oyo State, criminal code law of Osun State, criminal code law of Enugu State, criminal code law of Imo State, criminal code law of Bayelsa State, and so on. Then we have penal code. Penal code is the criminal legislation that is applicable in all the 19 northern states in Nigeria. So the major difference differences between these two codes are in relation to some offenses. Adultery cannot be found as an offense in the criminal code, but it can be found in the penal code. Drinking of alcohol cannot be found as an offense in the criminal code, but it can be found in the penal code. So if somebody commits an offense in Lagos or in Osun State, that person cannot be charged under penal code. It can only be under criminal code because each of them has limited jurisdictional application. So that is all I have to say. Then I must also say that I think I've made that point that they are the major criminal legislation in Nigeria. Then we have Sharia penal code also. Sharia penal code was brought into being in around 2000, I think first by Zamfara State. So because before then, we didn't have application of Sharia criminal law. We only had application of Sharia law in relation to civil matters. But since it was introduced by Zamfara State, so many other northern states have followed suit. And today we have some offenses that before the introduction of Sharia penal code were not known in Nigeria, like apostasy. A person cannot be charged for apostasy under Sharia penal code of some states in Nigeria. Apostasy is an offense which is committed when a Muslim changes a religion. Another offense which can be committed under Sharia penal code is blasphemy. So when somebody speaks some unprintable words against the holy prophets of the Muslims, then that offense can also be committed. And the nature of punishments also introduced by Sharia penal code, which those punishments are not under penal code itself, but they are under Sharia penal code, like stoning to death, amputation, and so on. Then we have Violence Against Persons Act. This is another criminal legislation, but it's very limited in its own scope. It deals mainly with domestic violence And this particular act does not have nationwide application. It only covers Federal Capital Territory, Abuja, and some other states in Nigeria that have also replicated this act as a form of law in their states. Then we have National Drug Law Enforcement Agency Act. This is also a legislation that deals mainly with drug trafficking and drug-related crimes. Then we have Economic and Financial Crimes Commission Act. This has to do with economic and financial crimes, so it's also limited in its scope. We won't find murder under these economic and financial crimes. But when we are talking about stealing, murder, robbery, armed robbery, and so on, we find them under Criminal Code and Penal Code. They are the major criminal legislation. Independent Corrupt Practices and Other Related Offences Act. This is also relating to corruption in both public and private sectors. So if corruption is committed in those places, a person can be charged under this particular act. Then we have same-sex marriage prohibition act. This is also very limited in scope. It has to do with same-sex marriage between people of the same gender. Then the Police Act. Police Act also has a number of offenses, and so many other statutes that also have criminal offenses in them. There is hardly any legislation that does not have some element of crimes where somebody can be charged with some crimes, but they are usually limited in terms of their scope. Even Central Bank Act, there are crimes under it, under which somebody can be charged. Electoral Act, there are offenses under it where people can be charged. Some basic principles governing criminal law. These principles are extracted from the Nigerian Constitution, especially under Chapter 4, which deals with fundamental human rights. Trial within a reasonable time. Every person accused or arraigned in court for trial has to be tried within a reasonable time. That is, trial of criminal cases should not be prolonged unreasonably. When a criminal case is taking 3 years in court, then this provision in section 36 of the Constitution of the Federal Republic of Nigeria in 1999 seems to be in violation. So trial has to be done as speedily as possible. Then presumption of innocence, that is contained under section 36(5) of the Nigerian Constitution. Every person accused of a crime is still presumed to be innocent until the contrary is proved. So no matter the gravity of offense anybody commits, that person will still be seen as an innocent person until the prosecutor is able to produce evidence in court showing that this person actually commits the crime. Even if a person is found in the act of committing a crime, that is not a conclusion that the person is guilty. The person still enjoys this constitutional benefit of being presumed to be innocent. So the person remains as innocent as any other person until the guilt of that person is established before a court of competent jurisdiction, and the process of trial is transparent and in conformity with relevant constitutional provisions. Another principle is open trial. So trial has to take place in public, that is in open court. It should be in a court that any member of the public can have access to, can enter and watch the proceeding and see that the trial is free and fair and there is no any bias on the part of the judge presiding over the case. But this may not be complied with if the interest of a minor, of a child, is involved. So, but barring that, then open trial, public trial has to be complied with. Then there is also section 36.6, which talks about given a defendant, that is a person standing criminal trial, or all the necessary facilities or opportunity to prepare his or her defense. So a person standing trial has the right to engage any lawyer of his or her choice. So somebody should not be compelled or be prevented from getting the services of a lawyer of his choice. And relevant documents that a person needs to prepare sufficient and adequate defense should be made available, or the opportunity be given. Then there is also section 35.4 of the Constitution, which talks about bail. Offenses that are bailable, then any person standing trial should be given bail. Bail is simply a temporary release that will from custody that will enable a person standing trial to come from home to attend to his trial. So usually that opportunity will not be denied unless there is strong evidence that if this person is released on bail, maybe going by the antecedents of the person will run away, the person will never show up for trial, or the person will interfere with evidence, with the evidence of the prosecution. Then in that regard, the person may not be released on bail. And again, if the offense with which the person is charged is a serious offense or a capital offense, for instance, murder, and the evidence available is weighty, that in the face of that evidence, that person may never come back. So then the person may not be released on bail. But generally, bail is a constitutional right to which persons accused of committing a crime are entitled to. Elements of an offense. There are two major elements of every offense that have to be established before a person can be found guilty. The first one is actus reus. This is a Latin term. The second one is mens rea. They are Latin terminologies, Latin concepts, which have to be complied with. Actus reus, in short, simply means guilty action. Guilty action. So the second one, mens rea, is guilty mind. So a person is not liable to be convicted unless evidence is produced to show that the action that somebody has carried out is one that is prohibited under a specific law. So if an action is not prohibited under a specific law, it cannot be a guilty action for which there will be criminal liability. And even if somebody has performed a guilty action, it has to also to be established that the person has the necessary mindset, the necessary mental elements, the intention to actually commit the crime. So if somebody is alleged to have killed another person, killing a human being is an offense, is a crime, is a prohibited action. So now, after it is proved that it is the action of Mr. A or Miss A or Mrs. A that has caused the death of another person, then the prosecution or prosecutor has to move further to establish mens rea, that this person killed intentionally. So that has to be established by evidence. I make an illustration here. The offense of murder can be proved by this. Once all these facts are established, then murder can be said to be proved. Number one, that a person has been killed or has died. So that is part of actus reus. That it was the action of the defendant that caused his or her death. That is still part of the actus reus. That the action of the defendant was intentional. So this is the mens rea. This is the mental element of what that has to be proved in a criminal case of murder. Now, how does one go about to establish the intention that the defendant really intended to kill? This can be established by evidence that relates to the manner in which the killing took place, by evidence that relates to the preparation, the kind of preparation that the defendant must have put into his action, which will show that from which inference can be drawn that this person must have really planned, must have really intended, must have really meant the outcome of his or her action. Then another example is the offense of rape. Rape can be established by evidence stating that the defendant had carnal knowledge of the complainant or of a victim. Now, carnal knowledge has been defined under section 6 of the Criminal Code to mean sexual intercourse. When a man has sexual intercourse of a woman who is not his wife and without the consent of the woman. So under section 357 of the Criminal Code, which deals with rape in Nigeria, only a man can commit this offense, and it can only be committed against a woman. But there are some other legislations now in Nigeria which have been trying to modernize this definition to be in line with some other developments in some other countries relating to the offense of rape. Take, for instance, in England, rape is no longer, cannot only be, even in England, it can still only be committed by a man because it is when a male organ is used to penetrate anus, mouth, or vagina of a woman, then rape is committed in that context. But in England, in the US, for instance, in some states in the US, rape can be committed by any person. It is by a person, not by a man only. So the definition is wide. So a man can be a victim of rape and can also be a perpetrator of rape. And a woman too can also be a rapist and can also be a victim of rape. But in Nigeria, under section 357 of the Criminal Code, which is similar to what we have under the Penal Code, is only a man who can commit offense of rape against a woman. Number two, that it was done without her consent. That is, that the woman was, there was sexual intercourse with the woman without her consent. Or even if her consent was obtained by fraud, it is still taken that there is no consent. Then, assuming an underage girl gives consent to an adult, that is still rape, because under the law, it is a child is not capable of giving consent. That the defendant was not the complainant's husband. Yes, under section 6, it is said that rape, if carnal knowledge, if taking place between husband and wife, then there is no offense. So I will later address the issue of defense to crimes generally. So it should also be established that the defendant is not the complainant's husband. So the number one, that the defendant had carnal knowledge of the complainant, that is actus reus, that is penetration of the private part of the complainant by the defendant must have taken place. That is actus reus, that it was done without a consent. So this is part of the mens rea in terms of the way it was done, not with a consent. And the way it was done, this person was determined, that is, the defendant is determined to carry out what he has proposed in his act to do, even without the consent of the victim. There are defenses to criminal liability. One of them is self-defense. Self-defense can especially come in the case of murder or any attack on a person's property. And this is well recognized under the Constitution, under section 33 of the Constitution, that is right to life. So if somebody wants to kill another person, then that person about to be killed can defend himself or herself. And where the person in defending himself or herself does anything that results into the death of the original, the person, the potential killer, then no offense is committed. But this is not easy. It has to be established in court The self-defense has to be established in court before a person can be set free, even when somebody strongly believes in that in this defense. Insanity is a defense if it is established by this may have to be supported with medical evidence, but everybody is presumed to be insane until the contrary is proved anyway. So somebody can raise this defense that as at the time of committing this act, it has to be as at that time of committing the act that the person is insane. The person does not have control of his or her mental capacity or mental stability. So this has to be established. But once, if it is established according to the law, then there is no crime. Provocation, that is when somebody acts in the heat of passion, in the heat of anger, in the heat of emotion, then that is provocation. Provocation cannot totally, especially in the case of murder, cannot totally erase that offense, but it can reduce murder to manslaughter if established. Then accident is more or less that it was not intentional. All these defenses are trying to attack the presence of intention, that even when a guilty act has taken place, as I previously explained in respect of actus reus and mens rea, even when an offense has been established to have been committed, then it has to be proved further that it was with the requisite mental elements, that is, it was intentionally done. But if accident is established, then there is no crime. Immaturity is also a defense under Section 30 of the Criminal Code. A person under age of 7 is not criminally liable for any act or omission that person carries out. So it is believed that a child under age of 7 is criminally incapable or is not criminally responsible. So if age is material here, then any person under age of 12 too may not be criminally responsible for committing or for omitting to do any act, unless if it is established that person knows quite well the consequence of his or her action. And again, it is stated in that Section 30 of the Criminal Code that a person under age of 12 cannot have carnal knowledge. So if a person under age of 12 is alleged to have committed rape, then that offense of rape may not stand, because there is that presumption. Unless the contrary, it is a rebuttable presumption anyway. It's a presumption that can be defeated by concrete evidence that a person under age of 12 cannot commit a crime. Then alibi. Alibi is also a defense. Is to the effect that somebody is saying, I am not even, or I was not at the scene of crime. So when somebody is alleged to have committed a crime, the person is simply saying that I couldn't have been the perpetrator of this crime, because if an offense takes place in Enugu, for instance, on 15th September 2021, and as at 15th September 2021, as at the time it was alleged to have taken place, the person alleged to have committed the crime is in somewhere in Osun State, then the person can be able to establish alibi. So once alibi is established, then there is no crime. That person has not committed any crime. Bona fide claim of rights. This is applicable to property when somebody honestly believes that particular property belongs to him. So this can be used as a defense where somebody is alleged to have committed stealing. So, and the person believes that the property is his or hers. So then that person, if bona fide claim of right is established, then that person cannot be convicted of that crime. Intoxication. Intoxication is also a defense, but this can only be available if it is proof that that intoxication affects the mind of the defendant and does not allow the defendant to know the consequence or the implication of what he is doing. But again, intoxication must not be self-induced. It is not when somebody deliberately intoxicates himself or herself and then raises this defense of intoxication. Intoxication has to be involuntary. So that's the end of this presentation. Go and get my books for more information on the Nigerian law. Thanks.